Thank you very much. And with that, we will call the first case this morning, the Detroit Alliance Against the Rain Tax versus the City of Detroit. Mr. Baker and Ms. Mithani, you each have 15 minutes. We will do as we have done on Zoom since April and let you have a short uninterrupted period of time, and then we will turn to each justice in order for questions. Mr. Baker.
Good morning, Your Honors. Madam Chief Justice, may it please the court, Frederick Baker. For the appellant, I wish to reserve 2 minutes. The court ordered argument on whether the court below correctly distinguished this case from Bolt against City of Lansing because Detroit has a combined septic and storm sewer system, while in Bolt, the City of Lansing's charge paid to separate its combined sewer system, allowing stormwater to be discharged to the river without treatment in a separate stormwater drain system. The Court of Appeals thought this meant that this case involves a regulatory component not present in Bolt. I'm quoting. We believe that is incorrect. As the Bolt court expressly noted, the City of Lansing imposed its charge to achieve the same regulatory purpose that Detroit has sought to achieve, which is to satisfy the requirements of the Clean Water Act and the conditions of its NPDES permit. Lansing merely chose a different method to achieve the same regulatory goal, which is preventing combined sewer overflows, which I'll refer to as CSOs. The same regulatory goal that Detroit chose to achieve by increasing its combined sewer system's treatment capacity. This was a choice, not a difference. Both sought to achieve a regulatory goal. Importantly, even though Lansing's charge was imposed to achieve a regulatory purpose, it was unconstitutional under Headley. And here, as in Bolt, the issue is whether, despite the regulatory purpose of the charge, Detroit's 2016 stormwater charge is a tax. The city asks the court to overturn Bolt. It argues that Article 7, Section 34 of the 1963 Constitution requires this court to liberally construe, and I quote them, and the amendment, and the article, Article 7, Section 34, liberally construe the Headley Amendment in favor of municipalities. They cite Associated Builders against City of Lansing, which is not in point, it's a prevailing wage case. I would observe that the voters adopted Headley 15 years after Section 34 in 1978. Section 31 of Article 9, the Headley Amendment provision at issue here, specifically forbids municipalities and taxing authorities to adopt a new tax without voter approval. A liberal construction cannot nullify this specific constitutional limitation. Certainly the city wants to evade that voter approval requirement. It approached Judge Cox in the federal court seeking to have an ex parte amendment to the order imposing the terms of its NPDES and other conditions upon it. Judge Cox properly refused to do that ex parte. They did that when this challenge was mounted to the 2016 charge.
Mr. Baker, I'm going to interrupt you now. I want to make sure my colleagues have an opportunity to ask you any questions they have before we eat up your clock. Okay.
Thank you.
Yeah, absolutely. Justice Markman, do you have any questions for Mr. Baker?
Thank you, Mr. Baker. I don't have any questions at this time.
Justice Zara?
Am I muted? Let's see.
No, you're good. I got you.
I can hear you.
Okay. All right, let me pull back up my notes in this case. Mr. Baker, this was an original action that was filed in the Court of Appeals, but I note that the Court of Appeals did not appoint a special master to engage in fact finding. There is no oral argument in this case. Do you know why it is that there was no special master that was appointed?
My clients are a citizen organization. They don't have the money to go to circuit court and have a special master or circuit judge allow us to engage in discovery and motion practice. We opted to base our claim on what the city has itself disclosed and published about this program. We believe the evidence available from the public record is sufficient, just as it was in Bolt case, in which I represented Mr. Bolt.
So if we find the Court of Appeals, or if we conclude the Court of Appeals findings in a particular area of the bolt factors are unsupportable, is it your position then that rather than trying to find out what the basis was for these documents that have been provided and upon which you rely, we should instead assume it's a tax under bolt?
We believe that the record before you in the tree stump of exhibits that has been filed collectively by the parties is more than ample for you to determine whether this is a tax or fee.
How exactly was the rate broken down when it comes to, for example, sewage versus stormwater?
You mean on the bill?
Yeah.
There is a separate charge on each ratepayer's bill. And in the case of this charge, the only bill that they receive is for the stormwater charge, because the property subject to the 2016 charge is not served by either water or sewer. These are unmetered properties, a little mine load that the city decided to mine by imposing this charge on them.
I get that, but when I'm trying to determine if it's proportional, it's my understanding that it costs more to treat sewage than it does stormwater. But when they put them together, it just becomes one charge. Is that the way it works?
Well, there are separate charges for sewer and for stormwater on a bill for someone who has sewer service. But this charge, which began as $750 per acre per month, which is an enormous new charge for these properties that had never received any bill before because they are unmetered and have no water or septic service, reflect only that charge, $750 a month.
I'm trying to determine proportionality, the second prong of the bolt factor.
Well,
so I'm trying to understand on a bill that had separate sewage from stormwater, how did they distinguish how much should be for sewage versus how much should be for stormwater? Do we know that?
Well, none of this charge would be allocated to sewer, septic sewer, but specifically, or sewer service, because the property subject to this charge are not served by sewer. However, because this is a combined sewer, all of the waste is treated as a single commodity or a single unit, and this charge goes toward paying the cost that is allocated to the storm sewer system by the Detroit Water and Sewer Department.
Again, I'm trying to understand whether it was proportional to the fee charge for the stormwater.
Well, we believe not, for several reasons, including the simple fact that these properties are subject to a charge only if they have impervious area, and yet that charge funds the treatment of stormwater discharged from property that has pervious area, which discharges stormwater when it is saturated during the wet weather events that cause the combined sewer overflows, the elimination of which is the regulatory purpose that the Detroit program seeks to accomplish.
I have no more questions.
Justice Viviano?
Thank you.
I don't have any questions at this time. Thank you.
Justice Bernstein?
Counsel, good morning and welcome to the Supreme Court. I just want to kind of look at the practical implications of this, and I'm hoping that you can kind of help me and guide me through this. You know, ultimately, if the court were to rule in your favor, what would the practical implications be of a city trying to oversee its water department? You know, ultimately, you know, would this have to then kind of go to a millage every time they needed to do any kind of basic things? I realize there's a test that we have to follow, but what I'm trying to get at is, should I be concerned about how cities are able to oversee their water facilities with basically the idea that every time they need to do something, to implement something, it would then require a vote? how would that affect cities' governances and the ability to kind of operate their systems?
Absolutely not, Your Honor. To answer the gist of your question, which is whether our position is that this charge has to be put to a vote every time the city wants to process wastewater. Of course not. The city has the power, and by the way, that the city does not oversee this charge or its implementation. It is imposed solely by the Water and Sewer Department, which under the city's charter has the authority to levy these charges without any legislative action by the city council. It is a power unto itself. Now, in designing a charge, the Bolt test simply requires that the charge, as Justice Zara has inquired about this charge, that the charge be for a regulatory purpose and that it be proportional to the benefit that is conferred upon the person subject to the charge. In this case, by choosing, and by the way, the third element, volition, is simply not at issue here. Even the Court of Appeals agreed that that third element is not implicated here. It's involuntary, and that does not invalidate the charge, but that element of the test is not at issue. So we all agree that there's a regulatory purpose being sought to achieved here. The question is whether the charge imposed is proportional, whether it is within that second prong of the Bolt test. We think it's pretty clear that the charge is not proportional to either the cost of rendering the service or to the benefit conferred by the service, because it is limited to a tiny fraction, probably about 14% of the property in the city of Detroit is subject to this charge because it is imposed only on impervious area. That means that pervious surfaces, owners who, homes are presumed to have a certain amount, and they receive a monthly charge that's pretty standard. I think it's $28 or something like that. But for larger properties, supposedly the properties have all been measured, their impervious areas have been determined, and the charge is imposed based on those asserted measurements. The problem is that by using impervious area as a proxy and imposing no charge on anyone else in the city, including the city's own streets, which are the largest single component of impervious area, which the city exempts as under the rationale that they're part of the collection system, while at the same time imposing charges on both the county and the state for the streets they own, which they are entitled to do under the decision they rely upon, the City of Detroit case. The city has imposed on a very small part of the property ownership population of the city the entire burden, the entire cost of processing this wastewater. The charge simply has to be redesigned in a way that spreads that burden over a larger, the entire property owning base. I see that your questions have exhausted the time I wanted to reserve is now running. So unless there are other.
You can stop talking and I'll try and ask my other colleagues and see how it goes.
All right. I hope I answered your question.
You did, thank you.
Yeah.
I'll wait for rebuttal. Thank you.
Justice Kavanaugh.
No question.
All right, you're saving some time. Well done. Ms. Mithani.
Good morning, Your Honors. May it please the court. Soni Mithani for the City of Detroit defendants. We believe this is a case about the authority and discretion that the Michigan Revenue Bond Act of 1933 confers upon municipalities to use their best judgment to determine what utility-related costs should be recovered through municipal rates. As we stated in our supplemental brief, Bolt versus City of Lansing does not account for the clear legislative directives that are provided for in Section 21 of the Revenue Bond Act. Directives that expressly address how public improvements like the city's combined sewer system can be financed and explicitly require that the costs related to those improvements be recovered through rates, not taxes. Nor does Bolt account for Section 34 of the Revenue Bond Act, which requires courts to construe the act in a way that secures the public health, safety, and welfare of municipalities. And finally, as Mr. Baker noted, Bolt does not account for Article 7, Section 34 of the Michigan Constitution, which requires courts to construe laws like the Revenue Bond Act and the Headley Amendment liberally in favor of the municipality. If the court were to apply Bolt as it stands today to the city's drainage charges, charges that undisputedly recover only combined sewer system costs, and conclude that those charges are unreasonable fees and thus unconstitutional taxes, it would also be effectively construing parts of the Revenue Bond Act as unconstitutional. This is contrary to the longstanding Michigan law that statutes in this state are clothed in the presumption of constitutionality. And thus, courts give deference to a deliberate act of the legislature, construing that act as constitutional, unless unconstitutionality is clearly apparent. There's nothing in the plain language of the Headley Amendment that renders the Revenue Bond Act unconstitutional. And so while we believe that the city's drainage charge is a reasonable user fee that is also compliant with Bolt, we also believe that if the court is inclined to grant leave to appeal, it would be appropriate to revisit Bolt to at the very least account for the legislative guidance that is contained in the Revenue Bond Act. And I'm happy to answer any questions that the court has about the city's drainage charge.
Thank you. Justice Markman?
I have no questions. Thank you very much, Counsel.
Justice Zara?
I'm very concerned about the proportionality of prong of Bolt. Can you help me understand how it is that it was proportionate to first charge $750 per acre per month at a rate that probably exceeded people's property taxes for the entire year on that property, then drop it down to $125, and then exclude some organizations like church organizations who complained about it, but not others? How is this proportionate?
Sure. So let's start with your original question to Mr. Baker. How do you divide the sewage costs and the stormwater costs? So the city makes a special attempt to make sure that the overall costs of the combined sewer system are allocated proportionally between customers who contribute drainage to the system and customers who contribute sewage to the system. And so we rely on measurements that we get from flow that comes in right to the wastewater treatment plant and some of our other facilities to decide what flow is wet weather flow, which really ties to stormwater, and what flow is dry weather flow, which ties to sewage. And so based on that proportionality, which is about 28 to 30%, that's how we allocate the costs of the system. Although all of the costs relating to those combined sewage overflow facilities are allocated to stormwater because those facilities were required by federal regulation and law to hold stormwater so that it can all be routed to the wastewater treatment plant to be treated. So that's the proportional allocation between stormwater and sewage. As it relates to the stormwater cost itself, originally we were not charging all customers who were contributing drainage to the system. We were only charging people who had a water account. And that was disproportionate, and the city was sued over that because the city was unfairly burdening certain customers who contributed drainage, but not all customers. And so the city made an effort to make sure that this was going to be a uniform charge that was assessed on all individuals and users of the combined sewer system that were contributing drainage or stormwater, in other words. And so when it did that, it brought on additional customers that had never been charged before. And so the city had planned in 2 years to basically bring everybody to a uniform rate, which would have been roughly around, I think it would have ended up being in the $500 range. But what happened is in the first year of bringing these new customers on and charging them that $750, the city realized that many of these customers were experiencing rate shock. So it implemented what is a well-known rate setting mechanism called a phase-in. It's used in regulated utilities all the time, which are, private utilities that are more heavily regulated than municipal utilities are under the state law. And they use
I get it, because I have questions and everybody goes into their argument when I ask a question. So I get it. You phased in a rate. So you went from $750 to $125, and you chose to not charge churches and then charge churches eventually. Is that your answer on proportionality as it relates to that?
No, churches have always been charged. What happened is we had new customers that were coming in. We had residential customers who were transitioning. We had customers who were being charged on a meter basis that were transitioning. All of those customers were part of the phase-in and transition. And at this point in time, everybody but one class is paying the same uniform rate. And that last class will be phased in the next year or so. And so in the next year, everybody will be paying the same uniform rate.
Okay. Is the, do you charge counties for runoff from county roads?
We do charge Wayne County and the state of Michigan, but both of those entities have consent judgments that dictate what the terms of that charge have to be. So we're bound by court order on that.
So that's yes.
Point.
The answer is yes. Is that right? The answer is yes.
Yes, absolutely.
Okay. Do you count for the city streets as having some runoff?
We do not, because those are part of the conveyance system, and under the Revenue Bond Act, properties that are part of the conveyance system do not have to be charged.
Okay. Is there a breakdown between drainage charges for impervious acreage versus water runoff from pervious acreage?
No, we only assess everybody's impervious acreage. We individually measure impervious acreage for every user. And
why is that proportional?
That's proportional because most of the studies that are in the record evidence that we've provided show that impervious acreage is the #1 contributor to stormwater.
But pervious acreage, depending on how hard it rains, contributes as well, does it not?
But everybody gets the same benefit of the assumption that pervious acreage is 100% permeable. Everybody gets that same benefit applied to them.
But it becomes disproportionate when property owners have nothing but pervious acreage. They are paying for the runoff from those who have, from property owners who have impervious acreage. If they have nothing, they have a parking lot that's completely paved. They're paying for the person who has a gravel lot or a dirt lot who also has runoff. They're paying for them, are they not?
No, I mean, they're paying their proportionate share. Again, the test, even under Bolt, is that it needs to be proportionate, not exact. And if you look at the historical case law here, the overall test was not that it had to be specifically individually proportionate. The overall test was that in the aggregate, the revenue had to match the cost of overall regulation. And that is clearly the case here. There's no additional revenue being generated by our charge.
The revenue is being charged only to what Mr. Baker describes as 14% of the of the area of the city. Now, I don't know if that's accurate, but I do know you're admitting to me you don't charge for city streets, you don't charge for pervious acreage, because everybody gets the benefit of that. But not everybody gets the benefit of that when your property is completely impervious. I've been on golf courses, beautiful golf courses in the city of Detroit. They all have wonderful drainage. That's considered pervious acreage, but that drainage is going all into the rainwater system, is it not?
No, not necessarily. Most of that drainage is being held and retained and detained. And that's the point. The studies show that most pervious acreage, while there might be some runoff, most of the time that allows for retention and detention. And so that is a way that these homeowners and property owners avoid burdening our system. The way these people choose to develop their property does impact and burden our system.
You're telling me then that all of the rain that goes on a golf course is soaked into the lawn and none of it goes into the sewer system?
I mean, I can't say that with 100% certainty, but again, the test is not that it has to be exact as to property. The test is that it has to be proportionate.
The test is proportionality, and I'm very concerned about a fee that's only put on people who are deemed to have impervious acreage, when I know from common sense that water runoff goes off of lawns, soil surfaces that are sometimes compacted and goes into the sewer system.
Well, I would contend that the legislature has not prescribed in the Revenue Bond Act a specific methodology that we are supposed to employ for assessing this charge. The legislature has conferred that discretionary authority to the municipality. And in the Revenue Bond Act, we are required, this is not even optional, the legislature has required us to recover all of the costs of our combined sewer system through a rate. And the legislature has deferred to us to try to make the best determination of how to make that rate assessed upon all parcels. I mean, we could, there are other alternative methods that allow you to charge impervious acreage as well and pervious acreage. But the studies all say that any methodology, there are 3 that are accepted and the city has one that relies on impervious acreage, is an adequate way to measure stormwater flow and contribution.
Well, that's to be determined under Bolt. Wouldn't you agree?
Proportionality?
Yes.
I would contend that Bolt has to take into account the legislative guidance and policy that's been set in the Revenue Bond Act. The Revenue Bond Act dictates what is a rate and what is a tax, and it needs to be accounted for as part of the will of the people.
All right, thank you very much.
Justice Viviano?
Yes, thank you. Counsel, can you just help me understand one point that you discussed with Justice Zara, and that is, why is it that the county roads and state roads are not considered by the city to be part of the conveyance under the Revenue Bond Act, but the city streets are? Don't the county roads and the state roads have a sewer system under them, like the city streets?
The public improvement is what we own. We don't own the county roads. We don't own the state roads. We can't control the way they're maintained. We can't control the way that they're designed.
Well, I get that, but I'm guessing that however impervious something has to be considered impervious would apply whether the city has their streets paved by asphalt or concrete or something else, or the county roads. In other words, they're just as impervious as the city roads, aren't they? But the city roads are just as impervious as they are.
The point of the city not being charged for its roads is that the city roads are part of the city's conveyance system, right? They're designed in a way, and we have studies in the record that support this. They're designed in a way to facilitate the conveyance. And so the city itself, the city proper, is the entity that maintains all of those roads. But they're treated.
Does the runoff, is it conveyed from the sewers on the state and county roads, or is it that's not connected to the city system?
I do not know the answer to that question. I'm sure at some point it routes its way to the city system. But we do have consent judgments that actually have litigated the issue of what is the appropriate amount that those institutions are supposed to pay. And so their charge is somewhat less. And I think in part that probably is a reflection of what they add to the system.
If the city roads were included in this calculation, that would significantly lessen the charge. Do I understand that correctly?
It would have to necessarily. But again, under the Revenue Bond Act, the city roads are part of the property and part of the public improvement and are not required to be charged.
Okay, thank you.
Justice Bernstein?
Good morning, Counsel. If you could just help me, I want to basically see if you could respond to brother counsel's kind of assertions that I made when I asked the question about how would the city and how would other cities kind of continue their operations if they were forced to have to go to election on these issues. And he had given kind of a more elaborate response to that. And I'm wondering if you could take the opportunity to respond to his comments to my earlier question.
I mean, I think that if this particular charge is going to be ruled a tax, then this is a slippery slope down, having all sorts of municipal rates having to be voted upon as taxes. And that is going to be difficult because that makes these costs suddenly optional, right? It suddenly becomes optional to actually pay for water, pay for sewer, pay for stormwater management. And the Michigan Municipal League put in an amicus brief that sort of explained what would happen if in fact we had to put every single rate to a vote. And that would be problematic. And it would also be contrary to what the legislature has dictated as policy in the Revenue Bond Act. None of these issues are supposed to be put to a vote. Per the legislature, these are all supposed to be costs that are recovered through rates.
Thank you, Counsel.
Justice Clement?
No questions.
Justice Kavanaugh?
No questions.
Mr. Baker, you have a minute and a half to respond.
Thank you. Quickly, studies that Counsel refers to on rate methodology, the 3 types, do not reflect or take into account the Headley Amendment and its requirement of proportionality. The Bond Act, secondly, Revenue Bond Act, cannot override the Constitution. Thank you very much. The Headley Amendment governs when there is conflict between the two of them. Third, we don't dispute that the allocation between sewage and stormwater costs at the plant is correct. We think it's probably correct. These are experts. They know how to determine what's normal flow and what increase occurs during weather events. Fourth, if the city streets are part of the collection system, then so are the state and county roads. They also discharge to the sewers, and that's why they pay a charge for the processing of that discharge to the sewers. Council does know the answer to that question. She just didn't give it to you. Justice Holmes is remembered for his statement that the power to tax is the power to destroy. The court should recall that he went on to say that as long as this court sits, the power to tax is not the power to destroy. And we urge you to reverse the Court of Appeals and find that this is a tax because it's not proportional. And I also urge you to recall, in the words of Justice Marshall, that in considering this question, we must never forget that it is a constitution we are expounding, which he said in McCulloch against Maryland. Thank you very much, Your Honors, for your attention. Are there any questions?
Anybody have any follow-up questions for Mr. Baker? Thank you both very much. The case will be submitted.
Thank you.